Good evening to the participants, those who sat for the All India Bar examination on the 5th February. You are welcome to my online class. I am dealing the key, and today is the third day of dealing the key. By keeping the set D on the screen, if I keep the set A, B, C, or D, doesn't make any difference because it is only the 100 questions which are framed in different sets, in different hierarchy, or in the numbers, different numbers. But the total is 100. Is it clear? Yes. But I did not get the reply from the Jyoti. I don't know whether you are hearing me or not. Anyway, let me continue my class. I posted on the screen, welcome to an advocates who sat for the All India Bar Examination 17th Cohort 2023 held on February 2023, and this is the key deliberations online class on 8th. It is not 22, it is, please make the correction 02, not 20. 2023 answer key, it's me, the host, Professor Dr. Mohammed Saheb Hussain. Yes, in my last class, I was dealing up to this extent where I put the asterisk marks. Yes, I put here the asterisk marks. Yeah, because we dealt it, the father of the public interest litigation in India is nothing but Justice P.N. Bhagavati. We dealt that question. And the 82 question, that is, the Muslim woman has the option to be governed by the provision of the section 125 to 128 of the Criminal Procedure Code 1973, which section of the Muslim Women's Protection of Rights and the Divorce Act 1986 deals with it. Up to this question, where the options are A, section 5, option B, section 6, option C, section 7, option D, none of these. So I searched section 5 says about the right to dower not to affect previous next. Nothing contained in this act shall affect any right which a married woman may have under the Muslim law to have her dower or any part thereof on the dissolution of the marriage. And when you want to see the section 6, it is repealed. There is no section 7. Hence, the right answer for the 82 question is none of these. Participants, do you agree? Jyoti, unmute and give me the answer. What did you tick it? Unmute and give me the answer. The right answer for the 82 question is the D, none of these. That is the right answer. Then go to the 83 question. Which of the following is not a ground of void marriage under section 11 of the Hindu Marriage Act? And the options A, bigamy, option B, degree of private relationship, C, Sapinda relationship, D, child marriage. When you see the answer regarding the void marriages are concerned, any marriage solemnized after the commencement of the act shall null and void, and the position presented either party 11, that is the degree of the nullity, its contravention to any of the following. They said 1, 2, 1, 4, 5 of the section 5. It is unfit for the marriage, procreation, children, account of the mental disorder is there. It need to be established that the ailment suffered by her such a kind of such an extent it is impossible her to lead a normal married life. That is decided in the R. Lakshmi Narayan versus Shanti, but it is a null and void marriages are concerned. But when you see the child marriage also, it is not voidable marriage, it is a void marriage, not voidable marriage. A Sapinda as a relationship is a void marriage, but according to the given A, B, C, D, the right answer is B, degree of the prohibited relationship is not void marriage, it may be the amount to the voidable marriage. Participants, do you want to contribute anything? What did you take it for the 83 question? The answer is degree of prohibited relationship is the right answer for that one. Because here he had given the many other things which are siblings are there, and those are said to be the void marriages, and that's the explanation I have given you here. And now come to the point of the 84th question is concerned. Sapinda relationships means the first day we dealt it. A. 3 generations, 7 generation father. B. 3 generation mother, 5 generation father. C. 3 generation mother, 4 generation father. D. 2 generation mother, 5 generation father. The first day when you are making the key deliberations, we dealt it. The answer is B. That is the third generation mother and 5 generations father. Is it clear? Jyoti, give the answer. Unmute and give me the answer. And the next question is 85th question. Ridge versus Baldwin case law deals with. On the first day also we dealt this case law, if I have not been mistaken. The Ridge versus Baldwin case deals with the A. Corporation, B. Natural justice, C. State liability, D. Delegated legislation. So the right answer for this question is natural justice, not the state liability, not the delegated legislation, not the corporation. So the right answer for the 85th question is B. Natural justice. Now let us see the participants. Can you unmute and read the 86th question? Jyoti, unmute and read the 86th question.
Meaning of Adi alterum pattern.
Adi alterum partem.
Yes, sir. A person cannot be condemned without being heard. B. An adjudicating authority must give a speaking order. C. No man can be a judge in his own case. D. No one should fear the courts.
Which is the right answer you take?
C is meaning of
Adi alterum partem means before you are punishing any person, give the chance to him to say in his defense or her defense. That is the Adi alterum partem.
Okay, sir.
So among the ABCD, which is the appropriate answer here? Answer
A1.
Answer A person cannot be condemned without being heard. Means we have to give a chance to him to speak on his or her behalf any defense. That is the natural justice. Adi alterum partem. So the A is the right answer for the 86th question. 87th questions. Rules made by the Bar Council of India is exercising its rule making power under dash. A. The Advocates Act 1951. B. The Advocates Act of 1954. C. The Advocates Act of 1961. D. The Advocates Act of 1964. Which is the
C. Advocates Act. Advocates Act 1961.
Yes, the right answer is C. The Advocates Act of 1961 is the right answer. And the 88th question, an advocate may, while practicing, take up a teaching of law in any education institution which is affiliated to a university so long as the hours dealing during which he is so engaged in the teaching of law don't exceed dash hours in a day. Option A,
3 hours.
5 hours. Option B, 3 hours. Option C, 2 hours. Option D, 4 hours.
3 hours.
It is a 3 hours. You can work as a part-timer in any affiliated college when a practicing advocate is concerned. Yes.
Okay, sir.
89th question. In which of the following landmark case the advocate was held guilty of the professional misconduct as he had forced the court order? And we dealt this in the earlier classes. A. Pratap Narayan versus YP Raheja. B. Option Vikramaditya versus Srimati Jamila Khatun. C. Babulal Jain versus Subhash Jain. D. Srimati Pankajam versus B.H. Chandrasekhar. What answer that you ticked?
This one, Pratap Narayan versus YP Rahil.
Yeah, that is a Pratap Narayana. Even Vikramaditya versus Srimati Jamila Khatun also, it is a disciplinary action against the advocate. But here he asked misconduct as he forged the court order. So here in this case law, it was held that the respondent handed over him a forged stay order while no stay order was passed by the court in the case. After examining all the evidences and relevant facts of the disciplinary committee of the BCI came to the conclusion that the respondent advocate himself handed over him the forged stay order which was not passed by the court. The respondent advocate pleaded that the forged stay order was handed over to the complainant by his clerk. No, either the clerk handover or any other person in his office handover, he who should have take care of it to see whether it is a genuine order or not, passed by a competent court or not. Then only he has to produce in the court. Otherwise, he is the guilty of misconduct. So that is the case law which is made in the Pratap Narayana versus YP Raheja. Yes, 90th question. Read the 90th question. Unmute and read. Jyoti. Which of the following is not a real purpose of public interest litigation? A. Vindication of the rule of law. B. Facilitate effective access to justice. C. Meaningful realization of the fundamental rights. D. Getting famous and making wealth. Not real purpose of public interest litigation. If you happen to see the ABC a little bit irrelevant, but when you compare the D, it is not relevant at all. So the right answer for the 90th question is getting famous and making a wealth, not real purpose of the public interest litigation. 91 question. In Hussain Ara Khatun versus State of Bihar, dash emerged as a basic fundamental right. Option A, right to speedy justice. B, right to clean environment. C, right to free legal aid. D, none of these. And we already discussed in our earlier classes, it is the first case law in the PAL and it deals about the right to speedy justice because there are many under trials they are there as a vegetative state in the jails because of trial is not made it early and expedient trial is not made. That is the right to speedy justice is the right answer for the 91st question. 92 question. Participants, are you there? 92 question. Which of the following writ can be issued against the usurpation of the public office? A. Writ of mandamus. B. Writ of certiorari. C. Writ of quo warranto. D. Writ of prohibition. I already discussed earlier classes in my class when I was dealing for the All India Bar Examination 17th cohort. I already dealt how many writs are there and what are the function of the writs. And if you happen to just reel and go back to the memory, the right answer is quo warranto. In what capacity that you are continuing the office. The writ is called writ of quo warranto. That means 92nd question, right answer is C. Is it clear? Say yes, Jyoti. Again, I could not see your microphone. Okay, the next 93 question. Under which section of the Environment Protection Act 1986 an appeal to the National Green Tribunal NGT lies? Option A, Section 4A. Option B, Section 5A. Option C, Section 6A, capital A. Option D, Section 7, capital A. But when I checked it, I did not feel it, but in the key it is given, it is the Section D. Option D, Section 7, capital A. That is the answer is given in the key. Let us once again see the key, 93 question key. Yes, what is written 93 question key? D. This is the set D key which I have shown just now is. But when I searched it, I did not find the section 7 capital A. But anyway, you also try it, but the key is given over there is D. So now subject to the correction, that is about the 93 question. 94 question, which one of the following fundamental duties relate to the environmental protection? So A, Article 51, capital A, small b, and B option, Article 51, capital A, small g. C option, Article 51, capital A, small j. D option, Article 51, capital A, small
జస్వేకి
j.
ఫోన్ చేసి మాట్లాడు
Yes, Jyoti, when you speak homely, you can mute it. And when you are speaking with me, you unmute it. Okay. 94th question, right answer. Jyoti, tell me.
Okay, sorry, sir.
Okay, no matter. 94th question, right answer, tell me. Which one of the following fundamental duties relate to the environmental
Article
protection?
51 AG.
After, that is option B, Article 51, capital A, small g is the right answer, because I already given the fundamental duty of each citizen regarding the environment is given in our constitution under Article 51, capital A, g. It states it should be the duty of every citizen of India to protect and improve the natural environmental, including the forest, lakes, rivers, and wildlife, and to have the compassion for the living creatures. So 95th question, Mr. A, who was aggrieved by an order made by the controller of an educating officer, made an appeal to the Cyber Appellate Tribunal. Later, Mr. Aggrieved by another order of the Cyber Appellate Tribunal may prefer an appeal dash A, option in any district court, B, option in higher tribunal, and C, option only in high court, and D, option only in Supreme Court. Which was the right answer among the ABCD? Jyoti. If you know it, you tell me. If you don't know it, you say pass on. Unmute and give me the answer. The right answer for this question is, after the tribunal, he may prefer an appeal only to the High Court. So here I have given the feedback. Any person aggrieved by any decision or order of the Cyber Appellate Tribunal may file an appeal to the High Court within 60 days from the date of the communication of the decision or order of the Cyber Appellate Tribunal to him on any question of fact or law arising out of such order, provided that the High Court may. So the right question is only in High Court. That is the C is the right answer. Is it clear?
60 days. Yes,
Okay.
sir.
The next question. Mr. X, a person who is intended by the Mr. Y, an originator, to receive the electronic records, is under the IT Act, that is the Information Technology Act 2000, known as dash A, option intermediary, option B, originator agent, option C, addressee, option D, key holder. Which is the right answer for this question? Multiple choice
Intermediary.
question.
Intermediary, sir.
No, wrong. It is a C, addressee. Addressee means a person who is intended by the originator to receive the electronic record but does not include any intermediary. So 97th question. The minimum number of the members required for the registration of a trade union is option A, 2, option B, 3, option C, 5, option D, 7. Which one is the right answer?
7 members.
7 is the right
7
answer.
members.
Persons provided for the no trade union of the workman shall be registered unless it has on the date of the making the application not less than 7 members, as it members who are the workmen engaged or employed in the establishment of the industry with which it is connected. Next question. Can you unmute and read the next question, 98?
If any advocate is aggrieved by an order of a disciplinary committee of State Bar Council made under Section 35 of the Advocates Act, or Advocate General of the state may prefer and appeal to the Bar Council of India within dash days of the date of communication of order. 60 days is the answer, sir.
Yes, option A 30, option B 45, option C 60, option D 90. So here India Code section delay, any person aggrieved by an order of the disciplinary committee of the State Bar Council and under section 35 or the Advocate General of the state may within 60 days of the date of the communication of the order to him prefer an appeal to the Bar Council of India. So the right answer for the 98 question is C. Yes, let him.
60.
Yes, 60 is the right answer for the 98 question. Yes, anyone can unmute and read the 99th question. 99 question. Unmute and read.
ABC Private Limited Company chose to convert itself into a public company It can do so by altering its member of association and articles of association and by passing dash A. Ordinary resolution, B. Special resolution, C. Board resolution, D. None of the above.
Should the right answer. We already dealt in the earlier classes, and I should
B,
get the
sir.
right answer in this.
B. Special
It
resolution.
is a B, special resolution is the right answer. See, the conversion of the private company to the public company is an alteration of the article of association by passing the special resolution. So that is the right answer for the question. And the last question, 100. Yes, anyone can unmute and read.
Doctrine of lifting off or passing the corporate will is associated with dash A. Labor law, B. Company law, C. Banking law, D. Service law. Option B, sir. Company law.
Yes, the doctrine of lifting or piercing the corporate will is associated with the company law, because a legal concept that separates the personality of a corporation from the personality of its shareholders and protects them from the being personally liable for the company's debts and other obligations. So, lifting the corporate, piercing the corporate will is connected with the company law, but not with the labor law, but not with the banking law, but not with the service law. So these are the 100 questions we dealt in a depth manner in 2 online classes. That is the 6th day, 6th February, 7th February, and today is 8th February. And the 2 I already posted, inshallah, by the God grace. I will post this one also in the YouTube, so that every person could have a knowledge that, sir, can you do the set A questions? Sir, can you do the set B questions? Sir, can you do the set C questions? Sir, can you do the set D questions? Now what I did is set D only. Any set may be there, but the only thing is in A set, the 1 to 3 is section, serial number questions, multiple choice questions are different. They jumbled it and they gave in a different sequences, but no one can go beyond the 100, the same questions. Is it clear?
Yes, sir. Yes,
Yes, sir.
And now they are not supposed to ask, sir, give me the set A question, sir, set B question you discuss, sir, set C questions you discuss. But I discussed total 100 questions, either in the set A, B, C, D, but only the sequence is different. And these are the things, but I already posted those who are going to write the state of Telangana junior civil judges, and whose last date is 1st March 2023 for the applying, and the exam is, the screening test is on 23rd March 2023. So I decided to commence the classes from 6th March, as usual time, Indian Standard Time, 9:10 to 10 p.m. every day except Sunday. The schedule, I will give it sooner or later, but still the time is there. And from tomorrow onwards, perhaps I could not engage your classes up to the 6th March. Again, I will resume it and I will undertake the classes. With this, I would like to say goodbye and Jai Hind and good day and good night. Thank you very much.
Thank you, sir.
For patient listening to me. End of the meeting.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा। विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा। तव शुभ नामे जागे तव शुभ आशीष मागे। गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे। अहरह तव आभान प्रचारित सुनि तव उदार